Okay, we're now moving into Note 16, which covers the topic of securities law and corporate governance. Um, at present, the bulk of securities law, which is law dealing with the buying and selling of stocks and bonds and other type of financial um, assets, and corporate governance is greatly controlled and regulated by the federal government. This was not always the case. Prior to the Great Depression of the late 1920s and 1930s, the, there was almost no federal regulation of securities law. People were free to issue shares of stock, to buy them and sell them. There was also rampant fraud, rampant dishonesty, rampant Ponzi schemes rolling along throughout the economy. A number of states, New York in particular, where the center of the buying and selling of stocks in the country has been since the country's founding, attempted on the state level to regulate this, but it was very difficult to do because as soon as the New York tried to impose regulations, then people would move to other states and other places and continue with their nefarious activities. It was so bad that the state laws that were enacted to try and regulate the buying and selling of securities came to be nicknamed the blue sky laws. And blue sky meaning that for many of the pieces of paper, the securities that were being sold to poor unsuspecting investors, there was nothing behind them but the great big blue sky. There was no real corporation, there were no financial assets, there was no production, and yet people were being sold these items thinking that they could hold on to them to preserve their the value that they had invested or that they would make further money in the future. And quite often it was nothing more than a flim-flam operation. It was a fraud. The Great Depression began with the crash of the stock market in New York. It resulted in approximately 25% of the workers in the country being unemployed at its depths. It basically cratered the economy. It caused a number of banks, which were also semi-regulated by the federal government, but very lightly prior to the Great Depression. It caused a large number of banks to fail. And in those days, if your bank failed, there was no recourse. Whatever deposits you had in that bank were lost, and if you owed money to the bank, the owners of the bank could take those loans, sell them to other parties who would still come after you to collect what was owed, even though all of your money that you had in the same bank had been wiped out in the bank failure and was lost. Things were so difficult, so bad, that when Franklin Roosevelt became president, one of the first things that he did was he actually closed all of the banks in the country for, I believe it was 90 days. Now just imagine every single bank being shut down for 90 days. And this was these were in the days before ATM cards and debit cards and before you could move money around on the internet or by wires. Most people did not even have checking accounts in those days. If you needed money, you had to go down to your bank, stand in line, and you had to withdraw it. So just think of an economy where that entire system has been shut down because it was collapsing so desperately. And as they began to study the situation, try and figure out what happened here, they learned that many of the banks had been taking the depositors' money and they had been investing it in the same stocks, the same fraudulent securities, the same bogus investments that the common person was being subjected to. The result of all this was that coming out of the Great Depression, the federal government, the Democratic Congress, with Roosevelt pushing them, established very tight laws and regulations for the buying and selling of stocks and other financial instruments, and created a regulatory framework and regulatory agencies to basically be a watchdog over these people to try and keep things on the straight and narrow. Now, the main agency that governs the buying and selling of stocks is the Securities and Exchange Commission. It was set up in 1934, again under Franklin Roosevelt, and it has several duties. It is to interpret and to apply the laws applying to the selling of stocks and bonds. It is to investigate regulations, and it can act as a prosecutorial agency. It can establish fines and even at times prison sentences for violations of its rules and of its laws. It issues rules. It oversees the issuance and the sale of stock. It regulates traders, brokers, financial advisors, and financial rating agencies. Right? It oversees the private regulatory organizations in security and the accounting industry, such as large accounting firms, various companies, the stock exchanges, various private appraisal companies, and it coordinates the federal jurisdiction with similar state agencies and similar state laws to make sure that there's a seamless blanket here to try and regulate all of this. Now, question might be, what are securities? Basically, a security is any type of contract, any type of agreement that can be entered into on the basis of someone taking their money, taking their assets, and attempting to invest them for a profit in whatever this entity is. They include stocks, they include warrants, debentures, bonds, stock options, puts, calls, promissory notes, profit sharing, fractional interest in oil, gas, and minerals, and investor contracts. The rule that the SEC applies to determine if something is a security and falls under its regulations has several criteria. All right. First of all, to be deemed a security, there would be a transaction where, number one, a person is investing their funds in some type of common enterprise, and they are expecting profits, and the enterprise is to be managed by others. The person doing the investing does not have the management power or the management rights. Any security sales at this point in time, if they are to be sold to the open public, not in a closed corporation situation or in a LLC situation where 2 or 3 people come together to set up a corporation, but if we're having a corporation set up and we're now attempting to sell shares of stock or bonds from that corporation to the open public, our process and our sales must be registered with the Securities and Exchange Commission prior to any sales taking place. Whoever is seeking to sell securities must create a document called a prospectus, and this has to be filed with the SEC for a period of time before any securities can be sold. The prospectus must be an attempt to describe the risk that is involved for somebody who's putting their money into this reality. It must first describe what is being sold. It must list the assets and give financial statements of the company that is making the offering of the security. They must describe the management setup of the company that is selling or the security, and it must state the proposed use of the funds that are being collected from the sale of these securities. And finally, there must be a statement as to whether there are any lawsuits or other negative factors known to the seller of the securities, about the company that's issuing them. As we said, this must be pre-filed with the Securities and Exchange Commission, and then there is a waiting period while the Securities and Exchange Commission studies and reviews and sometimes puts this out for comment from other people. During this period of time, the person trying to sell the securities can offer them for sale, they can solicit, and they can add, but they cannot have any transactions actually consummated or finalized during this registration period. Only after the time when the SEC has has approved the prospectus and has decided that this is in the public interest to go ahead with this, can the sale of the securities go on. Now, having said that, there are some exceptions to this. There are a group of people called seasoned issuers. Seasoned issuers are people who have issued more than $1 billion in assets over the last 3 years. They have at least $750 million of their own capitalization to back up what they're doing. And they can file, they still have to file a prospectus. They still have to put it subject to SEC review. However, they do not have to have a waiting period. The day they file, the day their prospectus taken in by the SEC, they can begin to sell on the open market. All right. Um, there are a number of small corporations. The rules vary. Some certain types of corporations under 5 million in value, or a sale under 5 million, or a sale under 1 million. Private placements where the securities are only being sold to a very small group of people who are investors and who may possibly know each other. They can apply for exceptions to the prospectus rule and to the waiting period rule. And if the SEC deems that they fall into one of these categories, then they can go ahead and sell stocks without going through the entire prospectus process and waiting period process. But we're talking about very, very small situations here. Normally, when a corporation of any medium size wants to go public, it has been privately held by shareholders up till now, and now it wants to go public and sell shares of stock on the open markets, it must go through the whole process. This process is very often referred to in the papers as an initial public offering or an IPO. And IPOs are extremely lucrative for the people who bring the companies through the process. They get paid millions of dollars to follow up and carry through with all this filing and all the things that need to be done. And IPOs are followed very closely because very often, if a company really has something that can be sold, that they can make money on, shares of stock are sold in an initial public offering, and then the value of them increases dramatically over the first couple of years. So these are highly followed things. People watch them. People wait for them to come out. They're looking to invest in them very often. If you violate these laws intentionally, you have committed a criminal act, you can serve time in jail for this. If you negligently fail to follow them, you and the company that's selling the securities can be subject to civil penalties and fines. Now, there are some defenses to all of this. If you forget to put something in the prospectus, you can argue that the omission was not material, that it would not have affected a person's decision to buy or sell. If a buyer knows there was an omission and still purchases, they cannot turn around later and make a complaint to the SEC about the omission. And then if the seller has exercised due diligence. Due diligence means that the seller did a reasonable investigation following generally accepted practices, which means they spoke to their lawyers, they spoke to accountants, they spoke to bankers, they actually studied what the corporation was doing before they put the stock on sale. If due diligence was done, then the people who are issuing the securities are very often exempt from penalties under the SEC. The Securities and Exchange Act, which created the Securities and Exchange Commission, again, passed during the Great Depression in the 1930s and amended from time to time, basically says that no fraudulent or manipulative statements or activities can be used in the sale and purchasing of publicly traded securities. There can be no insider trading. And insider trading is broadly defined in the law to basically mean anyone who has any connection with the corporation, who has knowledge that's not available to the general public, is not allowed to trade. They're not allowed to buy and sell on that information. All right. Many people have been caught and prosecuted and had to pay enormous fines. Companies have had to pay enormous fines over the years for violating this rule. So basically, when a company is about to sell shares of stock, when they're about to issue bonds, when they're about to enter in some new line of production that may cause the value of their shares to go up or go down, they have to be very careful about holding the information tightly, closely to them. And if the information gets out, the SEC is going to be looking to see who had that information and did anybody actually trade on that information to either make money or to protect themselves from losing money when the general public did not have the same information and was subject to losses thereby. The information that's subject to the insider trading rule, it's not just when the insider passes it to someone, but if somebody who's working in the corporation happens to mention information to a family member, and that family member then goes and tells a friend, that the SEC, the broadness of the statute allows him to go even after the subsequent individuals, basically down this chain of information. The person who provides the information is called a tipper, and the person who takes the information is called a tippee. All right? An outsider is anyone who receives information from somebody who's attached to the company, who knows what's going on with the company. And as we said, the outsiders, if they pass this on or if they themselves use it to trade upon, they are just as guilty as someone within the company. All right? The elements to prove all of this are that it has to be a material statement. There has to be knowledge that, oh, this could make a difference in the value of the stock. There has to be reliance by the purchaser on this information to either buy or sell stock, and there has to be economic loss caused by this information being released. There has to be a breach of duty by someone in the company. The disclosure is for personal gain, and the person disclosing, whether it be the initial person or subsequent persons, they have to have known that the information was confidential and was misappropriated, that it should not have been out in the public, that they should not be trading on this, that the general public does not know this information or have it in their grasp at this point in time. Now, you should begin to see how difficult this thing is, particularly in the days of tweeting and emails and all kinds of other information flying around the social media and the internet. I mean, you're basically asking companies that may have thousands of workers and hundreds of people involved in a certain project or a certain issuance of stocks or bonds to keep everything top secret until the event actually occurs and is made public in the press. It's almost an impossible reality to do in the present age with the way that information travels back and forth so quickly. And many business people complain bitterly about this when the SEC comes down upon them, saying, you're asking us to fulfill an impossible role here, that there is no way that we can keep information of any important type locked up this severely in the present day and age. There have been different attempts to amend these laws, to amend the rules, but there is a large part of Congress and a large part of the public that is rather negative towards any amendment or giving the stock brokerage companies and the New York trading companies any more power and wealth than they already have. So there's been little action to loosen up on this. If an officer or director or a large shareholder uses insider information to benefit, the corporation can actually sue them and grab that money in court, can recapture those profits on the idea that had this person been loyal to the corporation, they would not have used this information to benefit wrongfully. Now, there is something called a safe harbor. Corporations can give forward-looking statements about what they're working on, what they think is going to happen, their projections of what may be going on in the future, so long as they make it very clear that these are only projections and that they warn the public that the public is at its own risk if they buy and trade based on these projections. So this helps some of it because it allows some of the information to become quasi-public and kind of takes the wind out of the sails of any person, insider, who will be giving out information. Civil penalties, as we said, there can be, if you intentionally violate this law, there are criminal penalties. If you negligently allow the information to be released, there are civil penalties. And they can be as high as triple of the profits or the damages that were incurred. They can involve the rescission and undoing of contracts. They can involve disbarment. Now, there are many types of positions in the financial world today which are regulated by the Securities and Exchange Commission, regulated by the Federal Trade Commission, regulated by the Federal Reserve System. And you have to qualify, you have to be licensed, you very often have to take examinations to be a person operating in these areas. Disbarment means that once you are caught being involved in this insider trading activity, you can lose your right for the rest of your life to ever participate in these activities again. You can lose whatever licensing or credentials you've been given. So basically, they're pushing you out of this field. You'll never be able to work in the financial investment field again, is what can happen to you if you are caught doing this. All right. Um, Many states have their own security laws. Many times they are stricter than the federal laws and require more procedures on the part of the corporations to follow. And this is allowed. Congress has not claimed sole jurisdiction over this area. They have not claimed that state laws have to fall and are contradictory. And so long as the state laws are not attempting to undo or loosen what Congress has done, the states can pass laws that are the same as the federal statutes or even laws that are tighter. Okay. A large issue has always been corporate governance. Who runs and controls the corporations? Theoretically, it should be the shareholders, but in reality, what happens in most large corporations is a group of people, a group of shareholders put their holdings together, they gain control of the board of directors, and thereby they gain control of the officers, and then they're often running, and the corporation is basically controlled by them. And very often they're not a majority. They might be a sizable minority, but and bigger than any other group of shareholders. And they end up getting in control and remaining in control, and the rest of the shareholders end up just watching what's going on and not really having any power. The Glass-Steagall Act of 1933 attempted to undo some of the issues in the banking industry that led to the Great Depression. Under Glass-Steagall, banks were separated into two categories. And banks that took customer deposits were called commercial banks, and they were forever forbidden to invest in the stock market, to invest in securities, to basically play the financial games that go on Wall Street in New York every day. Separate banks could be set up as investment banks that would handle these things, and they were limited to basically high rolling depositors, to people who knew the markets and knew how to play the markets. This law was in force from 1933 through 1999. In 1999, when Bill Clinton was still president, his advisors convinced him, and they got the Democratic Congress to go along, to pass something called the Gramm-Leach-Bliley Act of 1999, and that undid Glass-Steagall. So for the first time in many years, 60-some years, the banks were allowed to begin investing in securities and to become involved in security trading. It didn't take long for the effects of that to come home and crash with a vengeance. By 2007, many of the big banks were in trouble. Their investments had gone bad. The real estate market, which they invested heavily in, was turning south. And by 2009, the Congress had to bail out the banks to the tune of almost $1 trillion to keep them from collapsing. After this, there were a number of attempts. There was a bill called the Dodd-Frank bill that attempted to rein in the banks again, but they never have been able to reenact the absolute prohibition that came under the Glass-Steagall Act of 1933. So the banks are still, to a certain extent, playing games and investing your money into various things. Now, one of the things that has changed for depositors since the Great Depression is that the federal government created something called the Federal Deposit Insurance Corporation for banks, and then later on NCUA, the National Credit Union Association for credit unions, so that all depositors have insurance backed by the federal government at this point in time. I believe the number is $250,000 at present, is protected if you have that money deposited in the bank and the bank goes under. So consumers have kind of been lulled into a sense of security here that they don't really have to pay attention to what their bank's doing. They don't have to worry about it, because even if the bank fails, federal government is going to, for most consumers, come riding in on the white horse to rescue them and to help them recoup their deposits. In the 1990s, there was a company called Enron, which dealt in the oil industry, and they, as many companies were doing at that point in time, they spent a great deal of time and effort buying up other companies, merging with other companies, creating a mini corporate empire within the oil industry. The operation was incredibly corrupt. The officers and directors of Enron were padding their pockets. They were using the corporate expense accounts for all kinds of lavish parties and trips and all kinds of other perks, cars. And eventually Enron collapsed, and it collapsed dramatically. The company had been doing so well. They had been, their stock had been going up and up and up for a number of years. They convinced many of their employees, they set up 401ks for their employees to invest in. They would match the 401ks, but in a 401k is a tax deferred account. It is a substitute for a pension program. So if you are working for a company that has a 401k program, you are allowed to invest money in, and very often the company will match money or put a certain amount of money in. You do not pay taxes on whatever money is put in at the time you pay it. You put it aside, but it has to be kept in an account. And again, companies can have restrictions. They can say that the money has to be invested in stocks of their company. And the idea is that you will hold on to this money throughout your working life, and then when you retire, you will begin to draw on it, and at that point you will pay taxes on it. And again, if it was a good investment, it will have grown, so not just the money you invested will be there, but more money will be there. And the theory being, we have a progressive income tax code. The more money you make, the higher percentage of taxes of your income you pay each year. When you're in your high peak working years, you're usually in a fairly high tax bracket. The theory is that you put money away during those years, you don't pay taxes on it then. When you have retired and you go to take that money out, you're in a lower income tax bracket and you would end up paying lower taxes on it. So not only do you get the benefit of an employer matching and letting the investment build up, and not just by your putting money in, but by the investment itself increasing in value, but you also have the benefit of hopefully paying lower taxes on it when it comes time for you to withdraw these funds. And again, Enron had a program where they had great incentives or requirements to make their employees invest in their own stocks. There was an actual pension. A pension is where you pay money into a system, your employer pays money into a system, and when you retire, that system will pay money back to you, usually for the rest of your life at a set amount. Even the Enron pension system was heavily invested in Enron stock, so of course when the corporation blew up, this all disappeared. People's life savings, their retirements, everything was wiped out in a matter of days. That caused such a shock through the economy, caused such a furor among the public, that Congress attempted to rein in corporations. Then in 2002, they passed something called the Sarbanes-Oxley Act, named after the representatives who were promoting it. And this act purports to regulate any corporation with over $75 million in assets. And one of the things it requires that officers and directors are required to review and personally sign off on the periodic financial statements of the corporation. And the officers must sign under oath. They must certify that they have reviewed the numbers. All right? And there must be periodic assessments from these corporations given to the public and again signed off on by the officers. One of the things that happened in Enron is that the federal government went in and tried to prosecute a number of executives, and many of them claimed that, well, we didn't know. We weren't in that echelon of the company. Only the top officers, only a couple of directors actually knew what was going on. We didn't know. They didn't let us see. Well, after Sarbanes-Oxley, you cannot take that defense. If you agree to be a director of one of these companies, if you agree to become an officer in one of these companies, you now have an affirmative duty to review the financial status of that company, and with an eye towards the hope that you would become a whistleblower if you see something out of order, something untoward, something illegal, that you would then give that information to the governmental folks that have the right to supervise your industry, and that you would provide that information to the shareholders so that they would know what was happening. Under Sarbanes-Oxley, whistleblowers are given legal protection. They can't be sued, or they cannot be retaliated against by the companies. There are no loans to be made to officers or board members by the company. All right? There are blackout periods imposed. So when the company is about to issue a statement, when the company is about to go into a new line, if they're about to issue stock, if they're about to borrow money, anyone who works for the company, their shares of stock are frozen. They're not allowed to trade them. So again, to prevent them from using insider knowledge to gain an advantage over the public at large. And that is called a blackout period when those shares cannot be traded. All right. There can be no destruction of documents. All documents, including emails and all other kinds of corporate correspondence, must be maintained for a period of years so that the regulators and the prosecutors can, and shareholders and other people wanting to file suit can get a hold of these documents if they determine that they need them, whether they would be helpful in determining what had gone on with the company. So, as you go forward in your lives, if you're asked to be a director or if you're going to be hired to be an officer of a company that makes over 75 million, and that seems like it would be a tremendously huge company, but not particularly so in the world that we live in today. Just be aware that you are taking on a great deal of responsibility and that you will be held personally liable for things that happen. There is no such thing as saying, I didn't know, they didn't tell me. Stocks and bonds and other types of financial investments are traded on exchanges. Now, the most famous of these exchanges are the New York Stock Exchange, which of course sits on Wall Street in New York, and then there is the NASDAQ. Now, the New York Stock Exchange is an interesting thing. It dates back to the 1790s. It dates back to the time when, although the English had taken over New York City, many of the Dutch merchant families that founded the city still live there. And literally, Wall Street was situated at a place where the town of Manhattan ended, and there was a wall fairly adjacent to the ocean in those days. The coastline has been pushed back in later years, so Wall Street's a little bit further away from the docks and from the water than it used to be. And there was a place along Wall Street, I've heard it said there was a big tree where the merchants would meet on a daily basis to trade, to buy and sell goods, to buy and sell shares of stock, and eventually this developed into the New York Stock Exchange. The New York Stock Exchange is a private entity. While it is heavily regulated by the government, it is not owned by the government. There are members of this. There are seats on the New York Stock Exchange, and somebody would have to have the money to buy a seat to become a member and to be able to have their folks go on the floor of the exchange and trade. Since 2005, the New York Stock Exchange has become a publicly traded corporation, so you can buy shares of stock in it. And they have also begun to issue licenses, so you no longer have to own a seat in order to have your traders operate on the floor. If you're interested in this line of work, you can go through the process to obtain a license, and once your company has a license, then you can put traders right down on the floor. And while computers are used, a lot of the trading is still done by people holding pieces of paper, yelling and screaming at each other today, the way it had been done for almost 300 years, from 1792 up into the early 1990s. Most major corporations seek to get their shares traded on the New York Stock Exchange. It's kind of a point of honor. It's kind of saying you have arrived. It's kind of saying you are stable, you are here. So companies, once they've made it big, one of the things that they attempt to do is to get their shares traded on the New York Stock Exchange. Now, there is another major exchange called the NASDAQ. And there are smaller exchanges. There are smaller stock exchanges that exist in many of the larger cities of the country. But again, they're not well known. They're not that heavily utilized. New York is still, for all intents and purposes, the center of the banking and financial industry in at least the United States and probably North America at this point. There are other places, London, Singapore, Paris, that have financial trading that probably equals New York. London might even exceed it. However, New York is the place in the United States. Now, there is something called the NASDAQ, the National Association of Securities Dealers Automated Quotations. And in this exchange, there is no trading floor. Everything is done by computer. And so their shares are bought and sold, and those sales are listed, and when the sales are listed, they determine what the value of the stock is at that point in time. Um, Initially, it did not handle the trades themselves, but it only provided information about the trades. And part of that was because it just wasn't the computer ability or computer capacity to actually handle the trades. Today, they're totally mechanized, and the um, all of the trading is handled by the NASDAQ, as well as reporting on what their members are doing. An over-the-counter trade is a direct trade or sale between two individuals, and that does happen from time to time, but normally in 99.9% of the transactions, if you want to sell, your stockbroker or somebody who's on one of the exchanges just puts a stock up for sale in the general marketplace, and in most situations, you never know who purchased them. It just goes through the exchange. You get paid for your sale, and that's it. And the same thing when you purchase, you don't really know exactly what individual you're purchasing from. Now, there are other type of financial things beyond stocks. There are bonds. A bond is a loan made to a corporation where they promise to pay back the principal at a set period of time and to give a certain amount of interest either at the end or to pay that interest periodically. There are derivatives. Now, derivatives are an interesting phenomena. They really only developed with the advent of computers, and what they are basically they're bets on other types of financial realities. So that you can buy a derivative, you can in some ways it's like an insurance policy also. So you can buy stock, or you can take out a loan, and then you can also buy a derivative where the derivative is basically betting. One side of the derivative is betting that the loan will not be paid, the other side is betting that it will be paid with the shares of stock. One side is betting that the shares will go up, the other side is betting that they will go down. So these derivatives are basically used almost, many investors use them to hedge their trades, so they'll buy stock hoping it'll go up, and maybe buy derivatives going in the opposite direction. So if the shares go down, they've lost other shares, but their derivative contracts will go up. But a lot of it comes down to almost being gambling. It's almost playing roulette with assets. And they fall into all kinds of categories. There are forwards, futures, options, swaps, collateralized debt obligations, credit default swaps. Most of these are traded over the counter. They are traded between individual companies and individual investors and not on markets. And there is actually, it is unknown how many trillions of dollars of these exist. And in 2008, when the banking system almost imploded, one of the things that was pushing it over the edge is that certain banks had lost money, Lehman Brothers had gone under, and that there were billions of dollars of derivatives that had been created betting on these institutions, and the fact that they went under caused a number of these things to suddenly come due and require immediate payment in cash, and the cash wasn't there. And again, Congress and the federal government and the Treasury had to step into the tune of almost $1 trillion to prevent the whole system from collapsing. There are several Congress people who in later years admitted in public and basically testified that they were told during the fall of 2008 that if Congress did not come up with this money to save the banking system, that at some morning in the near future, every ATM in the Western world would no longer work, and we would be devolved into chaos rather quickly. So we came right up to the edge, and that's not that long ago. 2008 is only 14 years ago. I certainly remember it. I was a middle-aged attorney at that point. I was dealing in real estate, and something was going on from the beginning of middle of 2007 on. Money seemed to be drying up. It seemed to be much more difficult for people to get mortgages. The banks seemed more catatonic about what they were doing and granting mortgages to people. And while someone like me on the ground floor in a province far away in Rhode Island, light years from New York and the stock exchanges, really had no idea what was going on at the time, we knew something weird was happening, something that hadn't happened before. Things were operating differently, and of course, as time went on, more and more came out as to what had been going on behind the scenes and how close we came to actual collapse. There is something called hedge funds. A hedge fund is an investment fund that pools capital from accredited individuals or from institutional investors. Now, an accredited individual is somebody who has a history of investing in markets, of buying and selling. There's a threshold amount of money that they have to have been investing over the years. At one point it was $3 million. It may have gone up from that. So basically we're saying that these hedge funds exist under the Securities and Exchange law, and they can take funds from individuals and they can turn around and reinvest them and try and make money, but they're only there for well-heeled people who know what they're doing, supposedly. And institutional investors would be insurance companies, banks, stock brokerage houses, who again, pension funds, who supposedly have the assets and who know what they're doing. The goal here is to try and prevent the little person from putting their life savings into a hedge fund and being wiped out and not even know what happened to them or why it happened. So we have basically created two classes of investors here. There is the accredited individual who can involve themselves in hedge funds and other high-risk things, and then there's a regular investor who has to go to their local stockbroker or financial advisor and is generally not allowed to play with the big folks. Most investment management firms are structured as limited partnerships or limited liability companies. Hedge funds are generally distinct from mutual funds. A mutual fund is a fund where somebody like Payne Weber or Fidelity would take your money, and instead of buying one type of stock in one company, they set up a fund, and this fund purchases stock in numerous different companies, and again, trying to hedge the bets, trying to make sure that if the economy is going down in one area, we also have stocks in another area where hopefully the economy is going up. And as an investor, you are allowed to buy shares in these mutual funds. So in effect, you are investing in the stock market, but without directly buying and selling the shares yourself, and without directly having to involve yourself with a broker to handle shares for you. All the shares are handled by the fund. The buying and selling, the trading is handled by the fund. All right. These are open to your regular investor, but they are highly regulated. The hedge funds are not, as we said, open to your normal regular investor, but they are far less regulated, and it's far easier to lose your money in a hedge fund than in a mutual fund at this point in time. This is a very complicated area of finance. It's a very complicated area of law. As I have said about some of the other areas that we've talked about, there are lawyers who do nothing else in their careers except handle securities law, handle the law of financial instruments. There are bankers and stockbrokers who specialize in these things and spend all of their time dealing with them. It's very interesting, very dynamic area. There are millions to be made. There are millions to be lost in it. It's something that the average person doesn't really encounter that often, and most Americans are rather ignorant about all of this. But these are the folks that are pushing and prodding and pulling on our economy, and things that they do can have an effect on those of us on Main Street, as they call it, those of us who are not involved in the financial markets. And this has become a bigger and bigger and bigger part of the economy. If you went back to the 1960s or 70s, the financial industry was only 3 or 4% of the entire economy. It's somewhere upwards of 30% of the entire economy now is involved in the financial industry. So if it does poorly, the entire economy does poorly. There are far more things we could go into here, but they're not really a subject of this course. Any of you who are